Okay, good morning, everybody. Welcome to today's open forum. Today we have a very special guest with us for the first time, Carlos Martin, Forest Lake Law. He is the attorney there and excellent real estate attorney. And Carlos, I'm going to turn it over to you. Thank you very much for coming in. We appreciate you.
Well, thank you so much. A little bit of myself. I've been practicing over 10 years now. Forest Lake Law this past March celebrated 10 years. And then before that, I worked for an additional, I think I've been practicing for 12 years now in different areas of law. But since I opened Forest Lake Law, we've always focused on probate, family law, and real estate law. So we're going to be doing today, we're going to be speaking about probate and how it affects you guys and what are the steps that are necessary to take when you get a probate case. You will get a lot of them. Okay. It's always the situation. Mom dies, dad dies. You know, we have the heirs, we have all these issues that arise because of that. And as realtors, and let's be honest, it's about getting that sale, getting that commission. And it can't be done in a probate situation if you don't have the authority to sell the property. So let me just get the PowerPoint just to make it easier. And afterwards, I will be sending Ryan you a little checklist of everything that I've discussed, and also, in essence, what you should be asking your clients when you are in this situation. You print this out, you give it, it has the latest laws. The laws have changed recently. So that's a good thing for you guys, because it will allow you to save your clients money, and it will allow you to be able to do things. Oh, 1 second here. Apparently the new thing is a little different. Okay. So
Carlos, you're going to have to pick a different window. It's going to say
yes,
window.
yes. I'm trying to. Bunda would like to record. No, I don't need to record. For some reason, it's not letting me.
We may have lost Carlos. Oh, there he comes. He's back. All right, so now you've done the screen that you're on. You need to pick window up top. It'll say it has that. It'll have your websites there, whatever tabs you have, and then next to that up top on that box, it'll say window. When you pull up the presentation, sharing the screen. You're on and you're muted also, Carlos.
Okay, so let me see here. Here we go. Okay, perfect.
You should see.
Yeah, I'm trying to. There we go. Every time I try to present it,
There you go.
Okay.
And if you want to do slideshow on there,
I'm trying to. It's just not.
It's working now.
There it is. Okay, I can't see you guys, so that's okay. If there's any questions, I'm just going to close my door here. If there's any questions, I don't mind being interrupted. If you have any things that I don't like waiting to the end. But if it's something that is related to you specifically, we can talk after the class. But if it's just to the class, then we're good. Okay, guys. So selling property through probate. Okay, this is just a a realtor's field guide for you guys. I'm attorney Carlos Martin, like I said, and this is going to take about 45 minutes here. So when somebody dies, it changes the authority, okay, but not the opportunity, okay? The first thing that you have to do is find the legal owner of the of the property now, okay? Remember, a dead person cannot transfer property. If mom dies, if dad dies, that property cannot be sold, okay, unless it has two things. Unless it's in a trust and there's a new trustee, or we have to do probate, okay? Whether you have a will or not, whether you have a, you cannot sell that property because it cannot be signed over. So probate allows you to sell the property. It will give somebody the legal authority, the personal representative, the authority to sell the property, okay? As an agent, the first thing is, who has the authority to do this? Because they're the persons that are going to be able to sign. And then once we know that, we're going to be able to build an actual reasonable closing time, okay? Many times that realtors come to me, they're coming to me and they're saying, hey, I have a closing in 2 weeks, and we just realized that this person can't transfer the property because it belonged to their father, belonged to their mother, it belonged to their brother, their wives, whatever it is. Okay, so now you've put me under the gun, and the reality is that we're not going to be able to close in 2 weeks. I won't be able to get appoint you as a personal representative in 2 weeks. There is a very rare exception that we could do that, but for the most part, that's not realistic. And then what happens to you guys? Oh, we're going to have to now do an amendment to my authority. You know, we're going to have to extend the deadlines. We're going to have to push this forward. That makes you look bad. That makes it difficult for you to do your job because the client is under a certain impression. Our jobs, my job as an attorney and your job as a realtor, is to manage expectations, to put these people in the correct frame of mind. And that way you're going to look good and the client is going to be happy. Remember, happy clients bring more referrals, hopefully. Okay. Unhappy clients lose you 10 referrals. A happy one will get you 1 or 2 referrals. An unhappy client will lose you 10 clients. So we have to manage the expectations. And how do we do that? The listing is only as strong as the seller's legal authority. And if they don't have it, then that's an issue. So what do we start with? Okay. Not everything is a probate asset. Okay. For you guys specifically, we're only worried about real property, about the house that you're wanting to sell, about the property that you're wanting to sell. So sometimes it doesn't have a house, it's just a lot, you want to sell it, but that brings issue if we don't have the person with the authority. So, and remember, not all cases are probates, okay? About 5-6 years ago, I had a family member come to me and they're like, hey, mom died, we need to sell the property, we need to do this, we need to do a probate. You know, the realtor told me we have to do a probate. Okay, well, oh, and I'm so sorry. We should have started with this. Guys, don't lose your license by practicing law. Okay, any advice that you give your clients can be considered practicing law and can bring you issues. I usually start with my classes like that. Don't practice law. Let me do that. Call me. I've already told, well, actually, I haven't told Brian. Brian, all your realtors can call me and I won't charge them a consult fee. Carlos, this is going on. I'll give you the advice. And that at that point, you can tell your client, I spoke to the attorney. The attorney said this. Not me. The attorney said this. Why don't you give him a call and he could give you that. I will charge the clients, but I won't charge you guys to do an evaluation of your case and to make sure that happens. So back to what I was saying, not all cases are probate. If you have a deed that has joint tenancy with right of survivorship, that property goes automatically to the next person, and we don't have to do a probate. If you have a deed that says a husband and wife died, the deed automatically goes to the husband. We do not have to do probate. When probate comes into place is when you have common tenants, okay, or when you have, in the husband case, just one of the spouses and not the other. That happens a lot, believe it or not. Somebody gets married, they already had the property, they forgot to add the wife to the deed. Husband dies, now wife has to do a probate because she was never on the deed. Yes, they were married, but they weren't on the deed. So always look at the deed. That's the first thing we have to look at to see who is the owner. And if both people are dead, then we can't transfer anything. We're going to have to do a probate for the next for the heirs of the property. In Florida, there's 3 paths, but usually 2 of them only touch real estate. There's deposition without administration, there's summary administration, and there's former administration. Deposition with administration is just for simple property, couches, TVs, possibly cars, okay? Anything that is worth under 150,000, and for deposition without administration, it can't even reach 25,000. It has to be something that is very, very minimal in money. However, for you guys, we are worried, and I don't know if you can see my mouse, because I can't see you guys right here. Summary administration and formal administration. These are the ones that you will be dealing with almost 100% of the time. Okay? With summary administration, the property, it used to be 75,000, guys. As of July 1st of 2026, it has gone up to 150. That is great for you guys. That will probably work more with trailer homes. That will probably work more with condos. That will probably work more with apartments and things like that. Okay. However, the reality is that most properties in Florida are worth more than 150. Okay. So for the most part, you guys will be dealing with former administration. Okay. Both of them go to court. The prices are different. For summary administration is very fast, very efficient to do it. I can get you those letters within 2 to 3 months, and we could get the house sold with former administration, with summary administration. Summary administration is an order of distribution. It's not a shortcut. Okay. There's no personal representative appointed. The court identifies the recipients. The order controls who receives title. And this usually works when all the heirs, all the beneficiaries are at the same, in the same page. They're not fighting. Usually when you have just one sibling, okay, one heir, or maybe you have 2 siblings. When you have more than 3, usually it's an issue. But that doesn't take you out of summary administration, because summary administration, like I said, is when it's under 150, the property value. And remember, it has to be the entire estate. So house, bank accounts, retirement accounts, all come in together. If that money is over 150, you can't do a summary administration. Okay? If you have more than one property, you probably can't do a summary administration. However, and this is the catch-all, you can always do a summary administration if the deceased if the person that died has been dead for more than 2 years. At that point, the 150 doesn't come into play. At that point, you can do a summary administration at any time. If the deceased has been dead for more than 2 years, we can do summary administration. Doesn't matter if they have 10 properties. Doesn't matter if they have $1 million in the bank. Doesn't matter how much money. Creditors can't go after them, and you can do a summary administration. And summary administration, just to let you guys know, is typically around $3,500. Okay? So it's a great thing because it's cheap. Full administration, okay, is way more expensive, and it's because we have to do everything. Okay. Any questions about summary administration? No questions about summary administration, guys?
I have a question. Let's say if the owner of a property passed away less than 2 years ago, and the property value is less than 150K, but then there are other assets. Can we just first do summary administration for the property so that it can be listed, and then later on convert the summary administration into formal administration?
No. You could always turn it, yes, but I don't recommend it because it's just a headache. And it's what happens is you're just gonna your client is gonna have to spend more money in doing that because they're gonna have to pay twice the amount. Okay. So
Okay.
I recommend, here's the thing, and we'll talk about it when I get to the formal part. And I'm sorry I took the screen out. I just wanted to be able to see you guys when I ask the questions. But can it be done? Yes. I don't recommend it. I've had cases like that they've started with summary, and not because it didn't meet the requirements. Well, they met the requirements for summary, but they lied to me because there was other properties. There was 3 other properties. They only told me about one. And then once we found that out, the court was not happy with me. So I like to do things right from the very beginning. I like to make sure everything's done correctly because it will cause you guys problems. Okay.
And another question, would you be sharing the pricing as well, like pricing for summary administration?
Of course. It's $3,500. It's
Okay.
$3,000 for the attorney, $500 in cost.
Okay, thank you.
Okay. And that's pretty much the standard price for most attorneys. They don't deviate for that much. Like I said, summary is pretty standard. It's pretty fast to do. Okay.
Got it.
So that's summary. Formal administration creates a fiduciary duty with a court order of issued authority. What does that mean? Okay. The petition is filed. The court will appoint a personal representative. Typically is a family member. Okay. Once the personal representative is appointed, the letters are issued. And at that point, and remember, I said about 3 to 6 months with summary administration. With full administration, you are going to be with me at least a year. Okay. That does not mean we can't sell the property. That does not mean that we can't push it forward. But the client is going to be with me for a year because we have to do an accounting of all the estate and all the properties. So even if we sell the property, that money is going to have to be put in an estate account, and we're going to have to do an accounting for the court. So you'll be able to sell the property, you'll be able to get your commission, but I stay with the client afterwards for about a year, making sure everything is done correctly until the estate is closed. Okay, so it takes a lot longer. And also with summary, creditors are out the door. But with full administration, we have to allow creditors to try to make a claim against the estate. We always try to kick them out. We always try not to pay any creditors, especially if there were any creditors that are not attached to the home. A mortgage has to be paid. That's going to be done in closing. Okay. Anybody that has a lien against the property, that's going to be paid. But creditors will not be paid. We will try our best not to pay creditors because we want the heirs and the beneficiaries to get the amount. Okay. So who will you be dealing with as realtors? The personal representative. That is a person that has the authority to bind the sale of the home. And once we get the letters of administration, you will be working with that personal representative. So when does that become an issue? When you have a large family. Who's going to be the personal representative? If mom dies, dad's still alive, dad's the personal representative. Same thing if dad dies, mom is. The issue is when you have the kids, both parents are dead, there's 4 or 5 kids, and then the fighting begins. Okay? You want to make sure that the person that is the personal representative has, can do what they are saying they could do. So it's very important. Okay? If they can't get along, then we can appoint a neutral third party. I am working on a case right now which deals with dad has 2 children. One is a minor, one is an adult. He remarries. Once he remarried to a younger person, sadly, he had issues and he committed suicide. At that point, and I tell you these stories just to know what can happen and how could it go wrong. At that point, the wife, the children were on vacation at the time with mom. She did not inform anybody. She did not inform his family. She did not inform his kids. She did not inform the ex-wife. She left the body at the morgue. And the morgue was going to bury him at a pauper's grave. Because in essence, what happened is he had life insurance. She took the money. She locked the door and she disappeared. That is a problem because we started, once the family found out, they went, they reclaimed the body, they did a burial, they did everything they were supposed to, but she's gone. They have no access to the house. They can't go into the house, okay? Because she is the wife, So that created an issue. We appointed the elder son as the personal representative. She came back. We started the case over because she came back and she wanted to be appointed the personal representative. Between us at the office, we named the case, pardon me for the language, fuck them kids. She did not want the kids to get anything. She kicked them out of their house. She didn't let them get their passports. She didn't let them get their property. She wouldn't give them any information. It was a horrible case. Eventually, we had to assign a personal representative that was not her, that was not us. It was a neutral attorney that became the personal representative. That cost money, as you could imagine. But the court allows us to do that, and it's made everything easier. This is what happens in former administration. A personal representative is appointed. It could be family. It could be somebody a friend, or it could be a professional that is appointed. Okay? Very important because the person nominated has the ability, once we get the letters of administration, to be able to sell the property. And that's what you guys are looking for. The person that has the power to sell the property and to sign over and to sign at the closing. Okay? You must think about this as soon as you talk to these people. That's why I'm going to send you this checklist, because you want to build the timeline into the listing strategy. You open the case, you confirm the authority, you resolve to see if it's homestead or not. You do the contract because that's going to allow you to clear title and close the account. You cannot close the account. You can't get your closing if that person can't sign. So fast files do exist, but predictable files are better. And that's why I want to send you that checklist, that with a probate case, you want to go down the checklist that I'll be sending you. Avoid promising closings, a closing date before the title is confirmed. Okay. So, yes, you could use contract inspections, and you could get the court to approve contingencies when needed. But if from the very beginning, guys, you prep your client to know this is how long this is going to take, it's going to help you guys. It's going to make you look good because you're coming in with a clear plan. Guys, we got to do X, Y, and Z, and it'll get us to closing. And that's why we're doing these classes, because it will prep you guys. It will allow you guys to be able to be predictable. Okay. And when you're predictable, that will allow you to just move forward and your clients will be happy with you. Okay. Who may sign the listing agreement? Verify before you market. You don't want to put the house out there until you know who could sign it. So with a former administration, the court appointed PR. Once they appoint it, you get the letters of administration. Once you do that, if all the heirs are on place, then you could list the property and you're not going to have any issues. With formal, with a summary, who is the recipient under the orders? Okay. If it has multiple orders, like multiple heirs, then everybody has to sign. So with formal, only one person has to sign. With summary, all the heirs have to sign. What's that example? You have 3 siblings, and the court puts them all as the owners of the house. So think about it this way: they're all on the deed. Everybody has to sign. If everybody signs, you're good to go, and everybody will sign at closing. And then when we have a trust, and that's another class that we could discuss, when you have a revocable trust or irrevocable trust, who is the acting trustee? That's the person that's going to be signing for the property. Okay, the acting trustee. Very easy. How do you verify? You look at the revocable trust, and that's going to tell you who's the trustee. In a trust, usually the settlor, the person who forms it, is the first trustee. If it's husband and wife, then they both have to sign together. Or if it says one or the other, that's okay. And then if they both die, the next trustee could be the next son. It could be a professional, whoever it is. You have to read the trust and the trust certificate, and that's who's going to be able to look at it. Never rely on the person that comes and says, I'm the son, I'm the daughter, I'm the wife. No, look at the documents. So with formal, there'll be the personal representative. With summary, we look at the order, and then it'll tell you if there's only one or multiple owners. And then with a trust, we look at the trustee. Those are the people that will be able to sell the property. Very important to look at those things. And remember, guys, always call an attorney. You could call me. I'll look at these things for you, and I'm going to tell you exactly who's going to be able to sign. Or I'll be able to tell you, you don't need one. The property is listed as joint tenants with right of survivorship. The property is listed as husband and wife. So we don't need to do any of this. And it will save you time, energy, and possibly money. Okay? Who could sign the contract? Like we already said, we look at the record title. We identified if we need probate or not, or we look at the trust authority, and then we, if there's any contingencies that need to do, because that's going to be able to sell the property. Okay? We don't want to do, like I told you, hey, my closing's next week. Hey, my closing's in 2 weeks. That's an impossible closing deadline. It won't be done, and it's going to make you look bad. Okay? And you're running to the finish line, you needed to walk. Okay? This is a classic story of the turtle and the rabbit. Okay? Slow and steady does win the race. Okay? Power of sale determines whether the court must approve. Okay? If the will, and this is where important, this is why we're going to have to do another class on wills, trusts, and estates. If the will grants the power of a sale, then the personal representative can sell the property without the court's authorization. If the will does not say anything, then we have to ask permission. If there is no will, then we have to ask permission of the court. Okay? So this is a core thing under section 733 or statute 733-613. The will gives the authority the specific general power to sale. Then the PR can sell it without authority. If not, then the court has to authorize it. That takes time. That takes permission. That takes a hearing. That takes an order. Okay? Judges have thousands of cases. They will not rush just because you call me 50 times a day. If the client emails me every single minute, it's not going to change it because it's not up to me. It's up to the court. So what do we do to avoid that? Guys, everybody needs a will. Everybody needs a trust. You guys, everybody in this room that's talking to me right now, that's listening to me, you need at very least a will, and I recommend you have a trust. It avoids probate. It avoids this. Okay? And it'll make it easier for everybody to sell the property. No usable power of sale. No title passes until the court authorizes it. Okay? So we got to think into that, like I said, so it doesn't create issues. Homestead is a red flag issue that could rewrite the seller's list. Okay? Was the decedent a permanent resident of Florida? Was there a surviving spouse? Is there minor children? How does that the will attempt to devise it? Who are the heirs? Okay, so we need to look at the homestead issue, okay, because it will make it easier to sell the property. Okay, it might make it more difficult if it's not homestead. So we have to look at these things to see who's going to be the heir and who's going to decide it in these things. These are things that you will learn how to do. But once again, don't give the advice. Don't lose your license. Because remember this, and this is what I said in the beginning. Any advice you give your clients can be warranted as legal advice. Hey, don't worry. It's homestead. We could easily sell it. Okay. You just gave advice. Hey, title is clean. That's legal advice. Hey, this is not going to be an issue because of X, Y, and Z. You're giving legal advice. Just come to me and I'll tell you exactly what to say. And if I mess up, I'll get in trouble, not you. Don't lose your license. Remember, guys, the first time you deal with a person and close for them, everything goes well, they won't be an issue, even if you mess up. Who brings you issue? That person that you've sold 10 houses for, and then you messed up in the last one. Family members always give you issues. That's why it's not worth the commission sometimes with family. You work harder, and they're never going to be happy. Sometimes it's better to give them to somebody else and split the commission. Okay? So, like I said, homestead may pass outside the probate estate, yet it still needs a court order. Death, constitution of descendants, homestead petitions, order determining statute, then it clears title. The probate case may be the vehicle for confirming title, even when the home is not an estate assets available to ordinary characters. Why is homestead important? Because creditors can't go after it. Okay? The mortgage company, of course, they're the ones that gave the loan, but other creditors will not be able to go after the home if it's a homestead. Okay? So that's important because at title, at closing, that's where people are going to pop up and try to say they have a lien against the property. Okay? And if it's homestead, won't be an issue. When we use a discipline listing intake, deed, documents, docket. That's what I'm going to give you guys. You look at the deed, okay? You looked at the death certificate. You look at the documents, the wills, the trusts, amendments, and then you look at the docket. Once we do the probate, the orders, the letters, pending issues. Sometimes you get there and the house has already gone into probate. The probate is done. Okay, you're the realtor that got this. Okay, at that point, you need to look at the docket. So this right here is what will resolve issues before you do contract. Look at the deed. Okay, who's the owner? Okay, husband and wife, they're both alive. Not an issue. They could sell. Oh, husband, wife is dead. Okay, is it listed? Was the deed listed at husband and wife? Perfect. Husband could just record the death certificate. The property is his. We don't have to do a probate. That's why you look at the death certificate to see. That's why you need the death certificate, and you're going to need it at probate too. So you might need the death certificate for the deed just to record it, to transfer property to the husband or wife, or at the same time, if you have what's called the ladybird deed. Okay, I'm going to close the window because I just want to see you guys. And how many of you know what a ladybird deed is? Okay. Say yes, no, because I can't. Ryan is the only one that raised his hand. Okay. A ladybird deed is one of the best things in Florida. Only 5 states in Florida does it. It says this. It says, I am the owner of the property with my wife. I am transferring it to myself and my wife. However, I am listing my heirs on the deed. But these heirs do not have any power over the property. They cannot force me to sell it. They cannot force me to rent it. They cannot force me to mortgage it. While I am alive, I can do whatever I want with this property. I could sell it. I could lease it. I could rent it. I could mortgage it. I could do whatever I want. And when I die, it goes to my wife, and she still retains all those powers. And if she dies, it comes to me, and I still retain all those powers and a life estate on the property. And when we both die, all my kids have to do is record the death certificate of both of us. And at that point, that property goes to them. And now they are co-tenants in the property. And they could sell the property. They could live in the property. They could do whatever they want with the property. It avoids probate. So that's why we look at the deed. We look at the deed, and I'll go back to the, I'm sorry, I'll go back here. That's why we look at the deed, because you can avoid probate by looking at the deed. And you bring it to me, and I'll tell you, you guys got lucky. Don't have to do anything. Just sell the property. Perfect. You do a contract with all the owners, the kids now. Done. But sometimes they're dead. You haven't recorded it. You bring me the certificate, and I can record it for you, and makes it easier for you guys. Or they go to the county and record it. So if not, we still need the death certificate for the will and trust amendments for probate. So those are important things. If you use the intake I will give you, these things are all going to be in there. Deed, death, document, docket. Okay? Checklist to make your sale faster. Checklist to make sure that when you do your contract, everything is taken care of. Getting to closing with no issues is your mission. Okay? So, next thing. We want a clean listing for you guys. So we are going to be asking these questions. Who holds the record title today? Is the property in probate? Is it homestead, or is it a trust property? Who has the present authority to sign? Is the property do we need court approval to sell the property? And can title ensure the proposed closing path? These are the 5 questions to a easy sale of the home. These are green lights. We want all these to have green lights. If you don't, then we need to see how to get to green light. Okay? So who holds title? Okay, you find out that mom died, dad's been dead for 15 years, and there's 2 heirs. Who do you guys, in that scenario, who holds the title right there? And to that question, you guys could answer the question for me. Nope. Mom would hold title most likely, possibly dad. So the kids don't have it. We got to find out. Has the property been probated? Is it in a trust? Is it in a will? These are all questions I would be able to answer for you. And if we answer them all and they're all green, we're good to go. Okay. The listing must serve the estate and withstand scrutiny. So we want, the market value, strong CMA, conditional equity, exposure. We want to do the best interest of the estate, avoid insider favoritism, management, things like that. And we want documentation, offers, repair, explanation, net proceeds compared. Treat it as the beneficiary or the judge is going to review this. Okay? So when we do a probate, you guys are working with me. Okay? I want to get you to the finish line. I want to get this sale for you. So I will be asking things that will help me with the judge, with the estate, with the personal representative. We all work together as a team. If we don't, nobody's getting paid. Okay? Remember, you get paid from the sale, from the commission. The faster you work with me, the easier it is. And a lot of times you guys are working with me, most of the time realtors are the ones that are doing all the communication for the client. So it's very important that we have everything, all our ducks lined up in a row. We want to build the contract around unresolved legal steps. Okay? Approval, confirmation on the court authority, homestead, home title, make sure everything is good. Multiple recipients, all the signatures, unknown title defects. We got to cure it. That's going to take time. And that will give us the realistic closing and extensions. Okay, we don't want to keep on doing extension, guys. That makes you look bad. Sometimes we do it. We have no choice. But we want to make sure that it's done correctly. We want to make sure that everything is done so you guys are advancing and not having to go back and fix things. We want to fix, measure once, measure twice, cut once. Okay. Title problems are cheaper before it goes live. Okay. Old mortgages, judgments, municipal liens. Those are things titles are going to find, and then we're going to have to fix them. Okay. Sometimes we have to do that. So, title search is the first thing we need to do when you get a property. Okay. Go to title, spend that money, get the title search, and then it's going to allow us through probate to fix all these things. Okay. We want to fix all the issues early on before we actually sell the property. Okay. Quick question. How many of you guys do title searches as soon as you get the listing? Nobody? This is money once again. You need to do this. That will help you fix problems before you get any offers. Okay, as a standard, it's not that much money, guys. I align yourself with your, I don't know who you guys work with your title, but align yourself with somebody that, $125, $150 that you invest in the title, which you could get back in closing. You could put it in your contract. Okay, hey, I'll invest this money, I get it back, and now we know. You guys don't understand how many times realtors get to closing, and then I get the call. Hey guys, there's a lien for how you call this, a water filtration system. Hey guys, there's a lien for the solar panels. Hey guys, there's a lien for roofing. We're gonna have to fix that. Okay. If you put the house on sale immediately and then you find out, now you have an issue. Okay. And let's say, and once again, why is this important here? Because that's another class too. Well, because the parents died. They put, right before they died, they put a new roof and they didn't pay it. So they put a lien. So you're coming in not knowing as a realtor. The kids didn't know. The heirs didn't know. So now there's a new roof, there's a water filtration, there's solar panels, there's a lien on the property. The ones that I hate the most are the solar panels because they never connected it. But they still put a lien. And now you're trying to sell the house. There's a $40,000 lien on the property. The solar panels are not working. The sellers or the buyers are wanting the house because they love the house, but you have these issues. So getting an early title search before you get any offers is going to help you. Is going to put you in a position to sit down your client and go, what I like to call the come to Jesus moment. Hey, I could list this, but here's all the issues we got to fix. And it's going to avoid headaches for you personally. You're going to have headaches. You're going to have problems. Okay. So this is an issue, okay, that we have to get ahead of. Okay, I'll go back to the class right now. We're still doing good in time. So like I said, title problems are cheaper when things are done earlier. Okay, so trust administration is private, but the authority to still lives in the documents. So when you have a probate, that's public. Everybody knows about it. There's a court proceeding, there's orders, there's letters, the personal representative, is going to be that. That's all public. But with a trust, there's no need for probate. The acting trustee is going to be signing, and the trust terms may restrict the sale of the property. So these are issues that we're going to have. So what do we need to confirm? That the deed is actually placed in the trust. Okay. Once again, this is another class that we're going to talk about, but this is a big deal. I have realtors that have trust. And when they come to me to review it, they never put their properties in the trust. Guess what we're going to have to do now? A probate. You did not list the property. You did not fund the trust. What you were trying to avoid is going to happen. Okay? So that's for another class, but that's something you guys we need to go into. It is so important for you guys to do that. Okay? Case study when the executor has a will but no letters. Okay? The daughter wants to, this is a scenario, guys. The daughter wants to solicit mediate. The will names her as PR, but there's no probate. Can we sell the house? Yes or no? No. We don't treat the nomination as an appointment. We collect all the records. We collect the deed, the will, the death certificate. We refer it to an attorney to open a probate matter. And once we do that, we coordinate with the attorney, with the seller. Hopefully there's not a with the seller. Yes, of course. And then hopefully there's no buyer. But if there is, we now make it realistic and go, this is the time to get the closing. That might work for the buyer. That might not work for the buyer. And we go from there. Okay. So just because she wants to list it immediately, that's a red flag. Because we don't want them to be angry. What do, guys? We manage expectations. Okay. That is my job and that is your job. Manage expectations. The more you manage, the better success you're going to have, the better career you're going to have. People like honesty. Okay? And when you're blunt about it, they respect it even more. Okay? And if they don't, that might not be the client for you. Remember, every time you bend the knee, it's going to embolden them more and make it more difficult for you. You are not helping yourself. Something I learned very early on in my career is I don't need to have every client. When you get that feeling, and I'm going to close this so I can see. When you get that feeling, man, I shouldn't take this case. I shouldn't take this sale. Listen to yourself, because that's going to be the client that's going to put you through the ringer, and it's not worth it for the commission. Okay? You might think it's worth it, but it's not. Every single client that I've taken in my career that I've said, I shouldn't take it, has come back to haunt me. I have one bar complaint against myself. Okay. Why do I tell you this? Because it's a matter of when. You will get complaints against you guys. Okay. It's going to happen. It's not a matter of if, it's a matter of when. And I promise you, it's that client that you bent over backward for and try to do everything. Okay. Guys, if you get that feeling, if you get that itch, don't take it. And especially if they're wanting you to do things that you know can't be done, at least quickly. Okay? So it's very important to listen to yourself, to go to your broker, go to Ryan. Ryan, he has more experience than you. Ryan, this is happening to me. What should I do? Oof. Hey, let's get the attorney involved. Ryan will call me right away. Three-way, you're in the office. Carlos, what do you think about this, this? I'm going to tell you. Guys, this is a red flag for this. This is this. This is this. However, we might be able to do this if we do this, and this. Let's get the client involved. And I'll talk to the client with you in front of them. I'll be the asshole. I'll be the jerk. Okay? That's why you have me on your pocket. That's why you have me on your cell phone. For me to be the asshole and be the jerk and tell them, we can't do this for this. Why do I tell you this? I do this all the time with my staff. Clients yell at my staff constantly. Do you know who they don't yell at? Me. Oh, attorney, no, I didn't. And I don't allow them to yell at my staff. If my staff comes up to me and say, hey, they yelled at me, get them on the phone right now. No, attorney, I didn't mean that. Da, 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 da. Let me be the jerk for you and tell them the reality. That will help you. Okay? I am a tool at your disposal. Okay? Because we don't want you to lose your license. We don't want you to lose your hair, you go gray. Look at me. Look how gray I am. Okay? So, very important, guys. I am here to help you. Let's continue with that. So, we already know. I'm going to send you that list. Okay? We're going to go through it. And if they don't meet, that's red flags. So, we got another one. One sibling hires you. The order is enters the order to distribute the property equally to all three. Okay? So, can you do that? Yeah, you can do that. Okay? That's the case when we have a summary administration. The orders are entered. Okay? Usually it's one sibling that pays for everything. Okay? One sibling that takes charge. And then what we're going to do, we're going to confirm the order. Perfect. We're going to verify the title plan. Awesome. We're going to obtain signature from all the siblings. There was 3 of them. Perfect. And then we're going to address any disagreements. Well, I need to get paid from title the $3,000 because my siblings didn't pay. Okay. Let's see if they're all in agreement. And if they're not, we got a red flag. What are we going to do? Because remember, if 2 of them are in agreement, but 1 isn't, can you sell the house? No. So what do we do there? Now, this has turned into another real estate class, which is called partitions. Sorry, I closed. I like to see you guys. Okay? We got to do a partition. That's the forced sale of property. Okay? Stupid, but it has to be done. Okay? And now you're stuck. Okay? And that might be your exit out. Because now what happens is the one that doesn't want to sell it doesn't want you as the realtor. He wants his. So what are we going to have to do? We're going to have to go to the court and we're going to have to appoint a neutral person. Okay? So at that point, I don't want you to lose time, energy, and money in a closing that I can't get you to. So that's why we work as a team. Okay? So let's go back to the next one. And like I said, at the end, if you guys have questions, interrupt me. I don't mind. But we'll get to more. Another study is homestead, surviving spouse and adult children. The will leaves the house to a friend, a surviving spouse, and there's a surviving spouse and adult children. Okay? What happened here? These are red flags. He owned the house before he got married. He got married. They both lived in the house. It was their homestead. But the will lives it to the adult children, to a friend of his. Okay? You're going to have issues there. You know why? Because in Florida, you can't disinherit a wife. The will disinherited her. So we're going to have to do a probate. we're going to have to the right. You have spousal rights. She might say, okay, well, you can't disinherit me. I want a life estate in the property, or I want my 50% election. Okay, these are things that now it gets deep into attorney things. Okay, so with homestead, the wife can elect either to live in the house permanently, but she doesn't get, when she dies, she doesn't get to transfer the property to her heirs, or she could sell it and split it 50-50. Okay, and that happens when you have adult children of a different marriage. If they're the same marriage, no. But if there's a different marriage, then that's your only options. Sell it and get 50%, or live in the property until you die. The earlier case that I told you about the fuck them kids, she came back and she elected to live in the house for the rest of her life. That was not a good scenario. Why? Because the kids are going to have to deal with her until she dies, or she decides to sell the house. And at that point, she doesn't get to keep the money, but she could rent it, she could live it, she could rent it. And as long as she maintains it, she's there for life. Okay? Thankfully, this crazy person, because she was insane, she stopped paying the mortgage. She stopped paying the mortgage in the house. So she lost her life estate. So we've actually gone in, did an order, and now we have a realtor that's going to be selling the house. Okay? Just to let you know, there was an initial realtor in here I had to fire. Not fired, she just, we got it. The judge said no. Okay? Because of all the issues. Do you guys want to know how long this case has been going on? Would you like to venture a guess? We've been 3 years in this case. Nobody wants to be a realtor. You don't want to be 3 years in this deal. Okay? So let's continue with the case studies. Okay? I'm sorry. Now we're going to go to mistakes. Okay? That derail probate. Listing with the nearest relative. What did I tell you guys? Don't sell houses for family. You're never going to win. Calling the nominee the executor. He's not. Okay? Ignoring homestead. Once again, skipping the early title work. For me, that is the most important thing. Okay? Promising a normal closing. No closing is normal, guys. You don't know what's going to happen. Okay? Using the wrong seller capacity. And that means that the person that it comes to you, you think they're the person that's going to be responsible. They're not. Okay? And then assuming that a trust owns the property. All these things need to be answered, and there's going to be in that list that I showed you that I'm going to give you guys. You need to go through them. If you go through them, you're going to have more success. If you drill this into your head when it comes to probate, when it comes to death, and you just start with this, and you sit with a person, you goes, here's my list, guys. Let's answer this. And you answer it. You sit down with them and you go, okay, this, A, B, C, who's the owner? Who's the authority to sign? Hasn't got to probate. Is this in a trust? You do your title. Oh, okay, there's liens on the property that we're going to have to take care through probate. Okay. Once we do all those things and you have it all answered, man, we're going to go to the end easily. We're going to finish this easily. I promise you that. Okay? There might be hiccups, but there's going to be a lot less because you've done your due diligence. You've made everything easier for yourself. And if you make it easier for you, you make it easier for me. And if you make it easier for me, the only person that really matters is your client, the seller. They will be happy with you. So, like I said, probate listing checklist. And you've seen me say this over and over and over again because I want you guys to succeed. We need to verify the title. We need to verify the probate pass. We need to verify if it's homestead. We need to verify who could sign, who has the authority, the documents, death certificate. Is there a will? Are there orders and letters? What's the title commitment? Coordinate, probate, title closing, beneficiaries, and the deadlines. Once we have all these things, we're good. And if not, we just pause. Okay, we got the death certificate, we got the trust, we got the orders. Okay, who's signing? No? Let's fix that. Okay? Once you do all these things, the path to closing is easier. It makes it easier for you. Okay? So, this is the next class we're going to do. I'll get with Ryan. Avoiding probate is the best thing we can do. We don't want to have permission of the court. We don't have to want to be stuck for 3 to 4 or 6 months with summary. We don't want to be stuck in a formal administration. So how do we do that? Irrevocable trust. Oh, but I don't want to spend the money on that. Fine. Let's do a ladybird deed, which is enhanced life estate, a ladybird deed. Let's do a new title for the property, and you put all your heirs there, and you're good to go. Oh, okay, we don't want to do that. Oops, sorry. Let's do a joint ownership with right of survivorship. Okay? You're married right now. Let's verify that you have joint ownership with right of survivorship. That avoids probate. Okay? Beneficiary designation for non-real estate assets, cars, bank accounts. What do you do with bank accounts? You put your kids right now as owner upon death. Okay? You could go to the bank right now and say, hey, if I die right now, I want my kids to be able to get this without having to go to court. Okay? They just changed some of that laws. Okay? That you are able, if there's a small money, the bank has to give it to you with a death certificate. Okay? So those are good things. And then, like I said, have a will, get your deeds, make a revocable trust, and have a family plan. Okay? If you guys can see my face, please put it so you can see me. Okay? Everybody has a plan right now, for the most part. Okay? It's the worst plan you could have. I, as an attorney, had it for years. You guys want to know what my plan was? Don't die. Carlos, don't die. Okay? That was my plan. Okay? But that's not a viable plan because we're all going to die. Okay? So, you need a will. At the very least, you need your will, you need your powers of attorneys, and you need to have an enhanced life estate, a ladybird deed. That's the minimal thing you need. Okay? To avoid your kids having issues. Okay? Especially if they're minors. Who's going to take care? It's not even the money. Who's going to take care of your kids if you die? I love my brother. My brother's 33 years old. He lives on my property on a trailer, and all he does is smoke weed. I love him. He's not married. Not a burden. He works. He takes care of himself. He's okay. Do you think he could take care of my kids? No. Okay? My sister, I love her. She has 3 kids. One of them with autism, severe autism. She can't take care of my kids. And I love her. But she has a lot on her plate. So I had to come up with a plan. Okay, it's going to be my brother-in-law who will take care of the kids. We'll figure it out. Okay? He's married, has 2 kids, but they're all around the same age. They're older. Boom. Okay? So this right here, I'll go back to it, will be our next class. And it's going to avoid so many issues for you guys.
I have a question
Yes.
about revocable trust. What if a property's the deed is on the name of a revocable trust, the person who created it passed away, and the heirs cannot find the trust documents?
That's an issue. That's why you need to know who drafted it, who did it, to see if they still have a replacement. And if there's no trust, probate.
So the property deed was transferred to the trust name in 1996. The law firm that created the trust documents is dissolved. It's no longer there.
Probate.
And the probate? Okay.
Probate.
So can you still go through probate even if the deed is on the name of a revocable trust?
Yeah.
Okay.
As long as we could prove, because we'll be able to see the title.
Right.
And the title is going to say, as trustee of the blah, blah, blah trust. Well, that person died.
Yeah, that person died.
So we don't have a trust. The trust disappeared. We know that it's in the trust, but we don't have the documents of how it's going to be distributed. So then it goes, in essence, intestate. Okay? Intestate means that there's no will.
Okay.
And then it's going to be divided in equal shares with the heirs.
Okay.
Okay?
Okay, thank you.
So, so before you list, this is for you guys. These are the questions. Who owns it? Who could sign? And what must happen before closing? Those are the basic questions you always need to ask. And if you do that, you will have a successful listing and you will have a successful closing. Okay? Now, with the time that I've allotted, I'm right there 3 minutes early. I'm Attorney Carlos Martin. If you have any legal questions, here's my information. Here's my number. And you could also visit us at our website. We're here to help you guys. Let me close this right here. Oh, actually, I should have left it there a little bit longer. I apologize.
You can put it in the chat if you want, Carlos.
I'll do that too.
That'll stay there. We're going to stay on a little bit after you go, so that'll stay on there for them.
Okay, perfect. Let me see where the chat is right here.
And it's forestlakelaw.com, forestlakelaw.com if you guys need to look it up later.
Yeah, there we go. Forest Lake Law. That's my number. I've told you guys, I will not charge you for the consult. Call me. Let me be the attorney that helps you with this. Now, let's open it up. Any questions you may have? And I'm good.
I want to tell you, I want to say this, Carlos, you're going through those case studies and people don't have any answers for anything, which tells you that they're so well trained by me. They know not to answer things they don't know the answer to. And even if they think they know the answer, not to say it.
Ryan,
tell them to go talk to Carlos.
Ryan, are you like me? You don't have a grandmother anymore? Or your grandparents gone?
Yeah.
You're patting yourself in the back like I do all the time.
Yes.
So I love it. Guys,
but that's great.
You know that's great, man. I love, one of my passions is teaching realtors, anybody, to be honest with you. And I love when a brokerage brings in people to teach. This is very important. My hats off to Ryan for bringing me, really, because you guys are going to be put in certain positions that you don't know, and these classes help you. Okay, you need to be up to date. Okay, this presentation that I have is the 5th one that I do, that I revise, because the laws change. So I'm not like, I sat down for about an hour and a half. I looked it up and I go, oh, the laws changed here. Let's change this. Oh, let's do this. Let's do this. So these continuing education courses for you are very important. Very important. Okay. Because you don't want to lose your license. This is what I tell people. Do you know what your real estate license is? No? It's a credit card to make money. Do not lose it for anybody. Do not put it in danger for anybody.
Yeah, and just because you know something doesn't mean you have to say it.
Correct.
Sometimes you're wrong, and you can't do that. Even if you're right, you don't want to do
that.
Yeah,
and the thing is, like I said, I'll be the bad guy. You could say Attorney Martin said this.
All right, Juliana's got a question for you.
Go ahead.
Yes, quick question. I have a family. There are 4 siblings, but 2 of the daughters are the ones that have been putting money to the mother's property to update it and so that she can have, like, live okay in her house. Now they're trying to put themselves into the title. And they're trying to figure out what's the best option so that at the end they can get their money back.
Okay, so like I said, the best thing to do is a trust.
Mhm.
Okay, because a trust allows you to put in there, my daughter spent this much in the house. When the house gets sold, they got to get paid this amount first.
Okay.
Okay, that's the easiest way. Why? Also because it avoids probate.
Right.
Okay, and then they could bring the receipts. Hey, I've invested. So you don't even have to put the amount in the trust. You could put, my two daughters have invested a significant amount of money. When this house is sold, they could provide the receipts, they could provide the amounts, and they have to get paid first before. I imagine there's other siblings,
Yes, there's two more.
so you could do
And
that.
one of them, it's one of them, the only one that's married.
Yeah.
So like
The
that's
other thing, if you don't
two.
want to do a trust because it costs a lot of money to do a
Mhm.
trust, if you have the exact amount, you can. And I've done this in a ladybird deed.
Okay.
So I had a family friend come to me. He goes, "Hey, it's four of us, three boys and a girl. The girl was the youngest one by a significant amount. So when the parents went to retire, the three boys who were very successful gave the down payment to the parents.
Mm,
They each, like one of them gave $40,000, the other one gave $30,000, and then the youngest son gave $25,000. You know, they wanted to make a big dent in the thing. So what I did for them, and then the youngest daughter, she was like 14. She can't give anything. So what I did is on their ladybird deed, on their life enhanced deed, I put, from parents to parents. And then in the bottom where it says the heirs, I put the first son, and I put, he invested $40,000 in this property. He gets that first. I put the second son, he invested $30,000. He gets that first. The other one, he gets 25 first, and then the daughter, then after all that, they split it 4 ways.
okay.
Okay. So from the sale of the house, they're going to get their money back. It is a house that, it was a nice house, they $400,000 when they bought it, so the house probably is worth $5 now. They made it, and they've been paying it off for years.
Mhm.
So there's going to be that equity
Right.
that even though they get that, what was it? 40, 30, 25. So what is that? 85,
95.
95. Sorry. That's why I'm a lawyer, not a, okay. That 95 goes first to the kids, and whatever's left over in the equity gets split to the 4 of them.
The other kid.
Okay, so Juliana, that is a great explanation, and you know all that now. But what your brokerage wants you to say is, "Hey, client, you may want to consider a trust or a ladybird deed. Talk to Carlos."
Uh-huh.
Talk
So
to
my
him.
other question, Carlos, do you speak Spanish?
Yes, claro que sí.
Okay. Good. Okay, so I can send them over to you.
You can send them over. I'm learning Chinese right now.
Okay. There's one of them that doesn't speak any English at all. So,
That's okay. Not an issue.
and then you said there's free consultations?
For you.
Yes, for you guys, I do. For you guys,
wow.
I'll give free
Okay.
consultations.
Uh-huh.
For anybody else, I don't. So I'm gonna put on the chat. I'm gonna put my actual cell phone. Okay.
Okay.
Here's my rule, guys. That's for you,
Right.
not for the clients. Okay. That is for you guys to be able to get a hold of me. I
Right.
don't mind if you call me. Okay. That's my cell. That's my direct line. I will answer at all times. The only day I don't answer is Saturday. Okay. I'm a 7-day Adventist. It's my day of rest. I don't work for anybody on Saturdays. I might write you back and go, "Hey, I'll hit you up after sundown. I'll hit you up tomorrow." But that's the only day that I, for the most part, I'll answer. I'll be polite. But I'll say, "Hey, guys, it's my Sabbath. Do you mind if I call you back tomorrow?" And if it's an emergency, I mean, Typically on the weekends, it's because, I mean, you're not going to do a closing for the most part on the weekends, call me if you're going to jail, and then I'll get you the attorney to help you with that one. That one I will answer. That one I'll help you with that. Hopefully you never call me for that.
So
All right.
the consultation, what's the price?
For you guys, nothing.
No, not for us, but if I
For
was
clients, it's
to
300.
300. Okay.
300, and I throw it into the pot.
Okay.
So it comes out to be free because I tell them, look, I'll charge you, but I'll throw that into the pot. So if it's 3,000, I do that. So actually the last thing I wanted to show you, because I'm going to give this for you guys only. This is the old one. I haven't done the new flyer. And the price is going to go up. So I'm going to give this for you guys. I'll send, I don't know if I could attach. No, I can't attach it. Let me just share the prices of how much I charge for. Oh, by the way, probate, I will work with you if the client doesn't have the money, okay, to pay for probate. I'm willing to work and collect from the sale of the home. Okay. The only thing I do that is you got to use my title company, not me personally, the title company. Ryan, do you guys have a title company?
We don't have any affiliation, legal affiliation with Telecom.
Okay. Okay. So I have about two or three companies that I use that are trustworthy, that are good, that are fantastic. One of them is Simple Title, Jasmine Velasquez. She's in Kissimmee. Fantastic. English, Spanish, great. Then I have Premier Title that I work with. That one's in downtown. Lucy Lima. She's fantastic. The reason I say you got to work with those titles is because I know that they're going to pay me. I know that they're not going to screw me. So that's what I say. But for you guys, for wills, and I know we're going to do this, I'm going to make sure that you use this price right here.
Okay, we got one more question for you too before you.
Oh, go ahead. Go ahead. I'll answer.
Omaima, I muted you. Omaima, I was getting feedback from you, so I muted you. So unmute yourself, please. There you go.
Hi. My question is, death certificates, are they automatically recorded or?
No. You got to record them.
Okay, thank you.
You got to record them.
I do have some other questions in the chat if you'd like to review them and just.
Oh, sure.
I'll read them for you, bud.
Okay, and look what I did right here. I don't know if you can see that screen. This was the 4th of July special. This is what I charge for wills, transfers. That's for this is realtor prices, by the way. Okay. If you guys want to do your will, your revocable trust, and your or quick claim deeds or life enhanced deed. Okay. So that's your guys' prices. I'll send you a new one for Ryan to see, so you guys have access to it. But like I said, these are the things that I do for you guys. I usually charge more when it comes to trust, but for realtors, I believe it is a necessity. You guys need to have your trust done. You need your wills. Most of you invest in properties, and those properties are not safe. Okay? If you're in an auto accident, I can take everything except your homestead. Okay? Don't get your property taken away from you. Okay, questions?
I got more. If a deed says a married couple, is that automatically joint tenants with right of survivorship, and they do not have to go through probate?
Yes, if the deed says husband and wife.
Yep. Okay.
Then we're good to go.
If there's a trust,
yeah.
Okay. If there's a trust, do the creditors have a claim?
No.
Okay. Does life insurance pay out when someone commits suicide? I know the answer to that. After a couple of years, it does.
It depends on. Yeah,
there's a waiting period. I can't be planning to kill myself tomorrow and go buy life insurance. There's
correct.
A waiting period. Yeah.
Correct.
All right. Should we use? I have a life insurance license. Should we use a realtor? Oh wait, shouldn't we as a realtor wait until probate is completed?
No.
No, lead them to probate and hang with them. How
lead
do we
them to
handle
probate, hang with them, hold their hand. You be the intermediary. Like once again, this is a service here. We work in the service industry, believe it or not. So our service is our time that we're giving them. Okay, so hold their hand, make them be happy. Call me. get the authority. I usually say, hey, is it okay for me to talk to your realtor? Because
All right.
it makes it easier to get stuff.
Yeah. How do we handle the conversation with the seller after we've called you for advice?
Once again, just get their permission. Okay.
Yeah, just
I
send it
don't
to 'em.
mind doing a dual. This happens all the time. I get the realtor on the phone and go, hi, can I add X to the phone call? Yeah, of course.
Yeah, I want to be very clear about this from a brokerage standpoint and a liability standpoint. Don't call Carlos. Carlos tells you this and you tell them this, like a game of telephone.
No.
Do not do that. Tell them to go to Carlos. But you
Yeah.
can get an idea. Carlos will tell you, when I call Carlos for advice, it's going to be, Carlos, should I even deal with this thing or should I just run?
Yeah.
And
If you do that, what I recommend is I just spoke to the attorney. He has said this, but I'm not sure. Can you give him a call? And that way you're distancing yourself that you didn't give any of the opinion. The attorney did. Please give him a call. And that way it shows them that you're working for them.
Right.
You
can talk to an attorney, a judge, you can talk to whoever you want to, but you don't relay the message. You let them talk to them.
No.
Do you have business cards that we can give to clients? I'm sure that's a yes, but
yes. So what I'm going to do is I have one of your realtors. I'm going to have her stop by the brokerage, and she's going to just drop a box of cards for you guys to get.
Awesome. Malvis, do you have a question? I know you have a question for me, but do you have a question for him while he's here, for Carlos? Malvis, you're muted if you're trying. All right.
I'm sorry. Yes, I was trying to unmute myself real quick. So a property that is already listed on the MLS. The probate has been done. This is the other way around. A lot of this education, by the way, is great, has been towards the seller that, that the person died and what they need to do. But what when it's the other way around? That the house is already listed on the MLS.
Mm-hmm.
There is a personal representative for the heirs of that property. How can we as realtors verify that that person is the real representative if we don't have that information? I'll give you an example. There's a property on the MLS. They have listed the owner. The contract was written with the owner's name. That's on the county and the MLS. And it turns out that the property went through probate, and they do have a legal representative for the daughter.
Okay.
How we as realtors verify that that representative is the person that is authorized to sign and things like that? Do we call the title company to verify that?
Yeah. Always verify. You want to make sure, and that's the other thing. You can actually go to the docket. You can go to the docket and verify. And if not, you get them to me, and I'll verify.
But what is that docket? What does that mean?
Each county has what's called the docket, which allows to you to see what's going on with the case. Okay, so it'll tell you, and I really don't have that much time to explain this, but like if the property's in Orange County, okay, you go to the Orange County clerk of court, you type in the information, boom, it should come up.
Got it. Thank you.
Yeah. Well, guys, I'm sorry to let you go. I got another meeting at 12. But thank you so much. And like I said, you have my cell phone, you have my office number. Ryan is at, you can just contact Ryan and he'll get a hold of me. And like I said, I'm available to you guys, whether here or if you do classes in person, whatever it is. Like I told you, our next class should be wills, trust, and estates to avoid probate.
Awesome. Thank you so much, Carlos. We appreciate
Thank you guys. Have a wonderful day.
Awesome. Take care. Okay. Omaima, do we put the name of the deceased? No, it's going to be an estate. So it would be, if I were a personal representative of, let's say, a family member died, it would be Ryan Langley as personal representative. So that's how it will appear when probate is finished.
Thank you.
Okay, Malvis, You asked about short. Malvis sent me an email asking about short sale, the process as a buyer for a short sale. Malvis, you use a regular contract and then you put a short sale addendum, and the short sale addendum will say, it'll have some choices there. You need to do this correctly. Hit the one where the time periods start after the third party approval. Those of you who don't
Yes.
understand short sales, I went through on MLS some of the short sales in Davenport area. There's a bunch of them in Davenport, 55 of them or something like that. And so many of them are not bank approved yet. So what happens with a short sale is for those of you who don't know, if you do know, you can probably go ahead and log off. But if you don't know, I'll tell you. So let's say that I can no longer pay my mortgage. I'm gonna go into foreclosure if I don't short sale this house. Okay. So I'm gonna call Carolina, my realtor friend, and say, Carolina, I'm in trouble. Can you help me? And she said, we'll try to work this out. Carolina's doing a short sale right now. I see on her social media, and she's using Hien. You're working with Hien on it. Great short sale negotiator. That's awesome. So she contacted a short sale negotiator, Hien, who's with our company as an agent as well, and she does short sale solutions. So Hien contacted the bank, make sure the bank will do a short sale, worked out all the details with them, got Carolina everything she needed to list it. She's listing it as a short sale. Now, what Carolina's going to list it at a good low price. Okay, she's going to get offers. When she gets an offer, the seller's going to sign it automatically. I'm the seller in this case, so I'm going to sign it automatically. I don't care. It's not my money. I can't make a dime from this thing. I'm just trying to get out from under it. But what we need is a price that we can present to my lender, my bank, okay, that owns that has the lien on the house. The bank is going to approve or not approve this. So this house might be worth $500,000, but I'm trying to short sale it for $425 just to get an offer in. Once we get that offer, the bank's going to say, well, we think the market value is $500,000, but we'll take enough to get us out of this loan. We'll take $475. Okay. Now the buyer who thought they were going to steal my house for $425 when it's really worth $500, they might back out up to that. Okay. Well, we tried, right? All they did was write a contract. They tried. They didn't even make a deposit or anything yet. There's no reason to. Okay. So because I'm not the only seller now, the bank also has to approve. That's a third party that has to approve. So you'll see short sales say third party approval required, right? So now we don't have an offer, but we have a bank approved price of $475 because the bank said, okay, we would sell it, but not for $425. We'll sell it for $475. So now we have a bank approved price. So now Carolina's going to change her listing to say bank short sale, bank approved price. She's going to put it on her public remarks, realtor remarks. She can put that anywhere. That's perfectly fine. So now I know if Malvis is showing this listing and it says bank approved price, she knows this is a pretty good, this is pretty high likelihood that this is going to go through, but it still may take 30 to 60 days to approve it or something. It shouldn't at this point, but it may take 30 days. But my clock, she's going to use a short sale addendum and she's going to check the box that says the clock starts when we have final, when we receive third party approval, meaning once, who's the listing agent? Carolina emails her that the bank has approved this price. Now that is the effective date. Okay. So now if I have a 7-day inspection, it starts then. I've got to have my deposit in 3 days, starting then, not today, not when the contract was written, but then. So there you go. Hopefully, I hope that you understood that and how that works. And then from then, it's a regular sale. From then, I mean, the bank's going to be signing all the documents. The seller, me in this case, the person who's just trying to get out from under this note, I'm going to be signing everything. I don't care. They're going to need my signature on everything. I'm still the seller, but the bank is going to be approving everything also. So it's kind of another seller in the deal. Does that make sense, everybody? Anybody have questions on that? I know that was a fast explanation, but Carlos was a talker. So we're going to get going. Yes, Carolina.
For what you just explained, we got an offer, but they don't want for us to sign off on offers, like backup offers.
Whatever the bank says. Do what the bank says. Not
the bank is the boss. An investor submitted offer, but in their offer, they were they didn't want us to get backup offers. I don't
That's fine. You don't need backup. Backup offers are no good right now until a bank approves a price anyway.
Okay.
You can have a ton of backup offers. You know, I'll make one $100,000. I'll send you the contract here in a few minutes. right? But it's not going to
Okay,
be.
okay. So, okay. Okay.
All right. So, but you could take an offer for $100,000 to that bank. I know you got listed for 400 or something like that, but you, right. But you could take my $100,000 offer and at least get a bank approved price. Right. So they'll say, oh, well, that's ridiculous. We'll take 375, whatever it is. So there you go. When you list them though, Caroline, they wanted a bunch of comps and stuff, right? They wanted your stuff, or did you? Oh, they will for Ian's purposes of negotiating the short sale. They're going to want your comps. They're going to do their own comps. They're going to do a BPO.
Oh, okay.
So that's what that is. A broker. That's a broker price opinion. They pay or they pay a realtor $100 to drive by there and take a look at it, and then do all the CMA and all that stuff. It's not an appraisal. It's done by a realtor. That's why it's cheap, $100, and they use that as well in their negotiation. Okay. I hope that makes sense for everybody. I appreciate everybody coming. Doing great. Appreciate you having your cameras on. Donnie looks great. Look at him. Look at Carolina, Juliana. You guys all did great. Thank you so much for coming, everybody. Sorry it went so long. Hopefully you guys learned a lot. Anybody have any other questions before we go? All right. Awesome. Thank you, everybody. We'll see you next week. Yeah, somebody said something.
Thank you.
Okay. No problem. Take care, everybody.